Today, our webinar is Facing a Deposition, Smart Preparation. I'm Elaine Alston. I am the estate litigation attorney with Koppenbarger and Koppenbarger, and I've been practicing in litigation for over 37 years. I've handled hundreds of depositions. Today's webinar is intended for information and educational purposes only and should not be considered legal, accounting, or tax advice. It's intended as a general guidance. Every matter is unique. We strongly encourage you to discuss these topics with your attorney, your accountant, and your tax professional. Need help getting started? You're welcome to consult with our team today. We have 12 attorneys working full-time. We also have an of counsel. Pictured here are 10 of our attorneys. We have 2 new hirees, which we're very excited about. Lloyd Koppenbarger, he heads our estate planning department, along with his son, Larry Koppenbarger and Victoria Raymond. Mark Krause is also part of our estate planning team. Our business and tax, we have Catherine Grout and Kevin Vanderbroek. In our trust administration, it's led by James Kosaroff. We have Mark O'Brien, Meg Wilson, and I head our litigation department. And we couldn't do anything without our staff. And here is a relatively recent photograph of most of our staff. Unfortunately, a few members couldn't be present for the photograph. We have our main office in South Coast Metro, which is in Santa Ana, California. We have an office in San Jose, Temecula, Santa Cruz, Pasadena, San Diego, Sacramento, and Laguna Hills. I often work out of Laguna Hills office. If you're unable to meet us at one of our offices, we also meet many clients via Zoom or other virtual press. Today's agenda: what is a deposition? Preparing yourself to be deposed, staying in control, knowing your rights, and what comes next after the deposition. So first, what is a deposition and why it matters? Well, a deposition is a legal proceeding where you answer questions under oath, but you're not in front of the court. Usually it takes place in a conference room of an attorney's office, or perhaps occasionally at the courthouse in one of the meeting rooms there. It can also take place at a court reporter's office. They look like informal settings, just a table with a court reporter and a couple of attorneys and the deponent. Everything that is said there will be recorded by the court reporter. The court reporter is known as the deposition officer, and the deposition officer will swear the person in so that you would be testifying before, in this informal setting, just the way you would testify if you were in a court of law. The testimony becomes a legal record. In other words, this testimony can be read into court if you're unavailable. For parties, it can be read into court to use to impeach the party. It is very useful in the discovery stage to try to gather all the facts and find out what's happening. A deposition helps attorneys understand what each party knows and doesn't know. It helps to clarify timelines, people's intentions, what they did and when they did it. Attorneys use it to evaluate the strengths and the weaknesses of a case. So when a person is being deposed, the attorney watches them very closely to see whether or not they're going to appear very credible or be a sympathetic witness, or whether or not there's someone that they think a jury would dislike and disregard their testimony. Depositions are also used as a method to prepare for trial, to guide settlement agreements. Well, who is involved in a deposition? Well, it'll be the person who's being deposed. If you're a party to the action, your attorney will be with you. The opposing counsel will also be there. The court reporter who's going to transcribe everything will be there. If you're just a witness, you may or may not bring your own attorney with you. We can discuss that further later. There may be a videographer, and there may be other parties. For instance, if you're suing someone, that particular person has the right to be there. There might be other attorneys who are involved in the case, but who is not present is a judge. There is no one there to rule on any of the conduct or objections that are being made during the deposition. All of the objections, whether it be to how the deposition is being conducted, as to the questions, that are put on hold until the case is set for trial and you're before the judge. Deposition can influence whether a case settles. It very much affects the strength of your credibility. This is the time that you provide key facts for trial. So I want to emphasize that your statements there carry weight and they are on record. So preparation and accuracy and competence are extremely important in the deposition process. So let's talk about now preparing yourself before you have to sit down for deposition. The first thing you should do is take a look at the notice or subpoena. A notice of deposition are given to parties. Those are people who are involved in the litigation. So if you are the plaintiff or a defendant, you would be receiving a notice of deposition. If you're a third party, then you would be subpoenaed to appear. First thing to look at is to whether or not the deposition is going to be in person or whether it's going to be remote. A remote is essentially a virtual deposition. It's the same way as if you were in person. However, the court reporter may be located in one location. You might be located in another. Your attorney may or may not be with you actually at the same place, or may be on another virtual platform. The person who's going to ask you the questions may be in a completely separate location. However, a remote deposition is the same as an in-person deposition. It carries exactly the same weight. When you get the notice or the subpoena, take a look at what date and time are being proposed for your deposition. That's going to be the time and place and date for your deposition. If there's some problem with that date that you know about, for instance, you've got a doctor's appointment that you really don't want to have to move, or you're out of town, you need to contact either your attorney if you're a party to the litigation, or if you're a witness, you need to contact the person who issued the subpoena, and you need to inform them that that date and time is extremely inconvenient and that you would need to try to work out a different time. So when you're talking to them, be sure to have your calendar out and talk about a different time. The earlier you make that, the easier and then the more likely that someone is going to accommodate your request. If you've been subpoenaed, you will be required to be there unless you get an out from the person who subpoenaed you. The same thing if you're a party, your attorney will advise you that you need to be there, or there can be consequences. If someone fails to appear, if they've been subpoenaed, there's a fine and the court can issue an order requiring the person to appear. If it's a notice of deposition, again, a motion to compel can be filed to require the person to appear, and the court may well impose sanctions, monetary or perhaps issue sanctions if the person does not appear. Take a look at the subpoena to see and the deposition notice to see whether it's going to be videotaped. If it's going to be videotaped, that means you're going to be sitting in front of a video camera, and that testimony and that picture is what the juror or the trier of fact, i.e. a judge, will see if that tape is played in front of the judge or jury. The next thing is to take a look to see whether or not the subpoena or the notice of deposition requires any documents or tangible things to be brought to the deposition. You are required to make a diligent search for any documents or things that are responsive to the request in the deposition notice. Now, there may be some things that are objectionable, so if you have an attorney, that attorney will advise you as to which documents you should or should not produce. But if you have a document that's responsive to the deposition notice, you need to bring that to your attorney's attention and plan on bringing that document to the deposition. The deposition begins. You need to know your role, i.e., are you the executor of an estate? Are you a beneficiary? Are you the trustee? Are you a plaintiff? Are you a defendant? Were you acting as a supervisor? What was your role in the matter? And if you are, for instance, an executor, you need to know what your responsibilities as an executor are. If you're a trustee under a trust, you need to know what the responsibilities are for a trustee. If you're not sure, please discuss that with your attorney prior to the deposition, so you know exactly what you are being expected to have done or not done. You want to prepare yourself, so you need to make sure that you know the timeline of major events. In other words, you should review through your notes, through documents, so that you're ready to testify as to the major events that occurred during your case. You should also have at your disposal the key documents that you worked with during the matter. For instance, if you're a trustee, you should be familiar with the trust document. That means prior to your deposition, very close to the deposition, you should probably reread the trust. It may mean that you should take a look at the accountings that you've prepared so you can refamiliarize yourself with the contents of those documents and you won't be caught off guard. Before your deposition, your attorney will most likely have you come into the office or perhaps via Zoom to discuss the deposition process. First, the deposition process will be explained, and you will discuss what type of questions will be expected. A deposition process begins where you have a court reporter in a room, opposing counsel, and yourself and your counsel. You'll be sworn in. Then the deposing attorney will explain to you that you're going to be answering their questions and that you need to give audible responses. For instance, ahas and uh-uhs. You might know exactly what you mean when you're testifying at that point, but reading it in transcript, it would be very ambiguous. The attorney will most likely go through an area of saying, here are what I expect the questions will be, so you can at least anticipate and prepare yourself for those questions. The attorney will most likely provide you with some documents that they want you to review. Just as I talked about earlier, if you're a trustee, the trust document would be a document that you would want to review before your deposition. Your attorney will also try to make sure you understand between things that are relevant and irrelevant. The court, for instance, if you're in a car accident and somebody ran a red light, it is very relevant as to what color light you were looking at when you were being driven through the intersection where the accident occurred. It probably won't matter whether or not you had your phone on your knee or whether the phone was in your purse, what color purse you had with you. Those type of things would be irrelevant, but the color of the light or where the sun was may well be relevant. At all times, you must be prepared to answer truthfully, and not to volunteer extra information. In other words, you want to keep your answers basically to simple answers. Now, preparing yourself, what to wear. If the matter is going to be videotaped, your choice of clothing is very important. Generally speaking, a person should come either in business casual or professional attire. We suggest often neutral colors, gray, navy, black. That doesn't mean you can't wear a white shirt, doesn't mean you can't have as the picture here has, a blue tie. But generally speaking, you don't want to come in too much of a costume, if you will. You don't want to appear basically looking like a cowboy or making yourself look like you're Indiana Jones. You want to come in looking very professional. Most likely, it is not the time to wear your Rolex. It's not the time to wear your expensive jewelry. Most of the time, it should be just simple accessories. Yes, a watch, a belt, but nothing particularly too over the top, shall we say. Be sure the clothes are comfortable. You don't want to be in anything that's uncomfortable because you're under enough stress as it is at a deposition. As I say, if it's being videotaped, what you're wearing is extremely important. If the deposition is not being videotaped, what you wear is still telling the other side whether or not you will be a really credible witness. It's hard to have credibility if somebody comes in wearing a t-shirt with either a profane or perhaps a bit of a joke on it. Those things don't go over real well. So again, as I say, try to be business or professional attire. What to bring to your meeting. What you want to bring your reading glasses. You want to bring any documents or other things that you found that were responsive to the notice or the subpoena that you got. You also may want to bring any other documents, I'll call them attorney-approved documents, that have been used in the case. For instance, such as the trust. Even if the deposition notice did not require the trustee to bring a copy of the trust, you may well want to have a copy of the trust with you. And come with a calm and prepared mindset. Go back a little bit too here. In preparing yourself and coming to the deposition, I also suggest that people bring with themselves some Advil or Tylenol. Sometimes the depositions bring on a stress headache, and it's much easier to be deposed if you can dull a headache. So again, think about bringing some Advil or Tylenol, that type of something, in case you end up with a headache. Now, staying in control. We all know things can happen. Well, the first thing to do is listen very, very, very carefully to the question. Make sure that you understand the question. A lot of times attorneys will start out the question and you think you know what it's going to be. And in normal conversations, you could jump in and respond. But at a deposition, you have to let them finish their entire question, and then you need to respond. So be sure to listen to the entire question before you respond. Your response should be a direct response, relatively short if possible. You don't want to have a narrative. They ask you for a list of items. For instance, so they say, how were you hurt in the accident? If you've hurt your neck, your back, your right arm, and your left leg, you should say each of those items. Now, you need to be truthful, but we don't want you to guess. Now, I define a guess as if I asked you here today, all of you, what size is my dining room table? You have no clue, you have no idea. So at that point, it would be a pure guess. But if someone asked you how many words were on the screen that's in front of you, you could count them, so you could have an exact answer, or you could give an estimate as to how many, because you are staring at it and can make an estimate. So the difference between a guess and an estimate is that a guess is pure speculation. You really have no idea. You're pulling something rabbit out of a hat, so to speak. Whereas if somebody's asking for an estimate, you might not know. If you're staring at a table, you might not have a tape measure, so you couldn't say exactly how many inches, but you could look at a table and say, well, that's roughly 3 feet or 6 feet. So you could give an estimate. Again, answer the questions clearly, safely, and confidently. You get to control the place. So opposing counsel will often try to use almost a scattergun approach, where the questions come very, 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 very fast, and they're hoping that you will answer them very, very fast, and therefore your answers may not be as complete as they need to be, or perhaps you will not completely understand the question. So when they ask a question, pause when they finish the question and think before you speak, and then answer the question. Now, you are allowed to take breaks. Generally speaking, with almost no exception, the attorneys will ask you to answer a question before taking a break. In other words, not taking a break between when a question is asked and the answer. Occasionally, your attorney may say, we need to talk. We're going to take a break right now and we're going to stop. But that is only done in what I will call emergency type circumstances regarding a question. So basically, if you start getting overwhelmed, you've answered a question, stop and say, I'd like to take a break. Now, I want to tell you that your attorney may, after you answer a question, say that they would like to take a break. At that point, don't argue with your attorney. That's a hint that most likely the attorney wants to talk to you. It could mean the attorney needs to go to the bathroom, but very likely it means the attorney wants to talk to you about the subject area that you're going into. Now, we talked about answering the questions shortly and concisely, but truthfully. So do your best to stick to facts, not opinions or assumptions, unless you're asked to opine or you're asked for your assumption. And you don't need to explain your answer unless the question requires an explanation. So if they ask you, what color was the light? Then your answer would either be yellow, red, or green. And that would be your answer, one of those three. If they ask you, well, how long was it between when you entered the intersection and the car hit you, you can give an estimate because you were there, whether or not it's the exact amount of seconds, but you can answer that question. But you don't need to go into an explanation as to what you were doing and how it occurred. There are some traps that go in to deposition taking. One of these is when the opposing counsel uses a lot of leading questions. Leading questions are those that require a yes or a no. It's not a question that's calling for any type of explanation or calling for your opinion. Leading questions as to opposing parties, that is perfectly allowed. Leading questions as to third-party witnesses, most attorneys will object to those because at trial, you can't lead a third-party witness as a general rule. However, at deposition, because there's no judge there, there's nobody to rule on that objection, you will still be required to answer that question. At trial, the attorney who made that objection may say, Your Honor, I don't want that testimony read in because I objected on leading question, and therefore that question shouldn't be read in. And the judge may well say, no, that won't be read in because the objection is to be sustained. However, in a deposition, you will answer all the questions, even if there has been an objection, unless your attorney specifically instructs you not to answer. And the type of questions that your attorney will instruct you not to answer are things that would invade the attorney-client privilege, or perhaps they invade a privacy issue. But there's very few questions to which an attorney will instruct you not to answer, even though they have made an objection. Now, if in the leading question that they ask you, something is wrong, you need to make sure that you answer in the negative. In other words, if they said to you, the light was red when you crossed through the sidewalk, if that's wrong, you need to say, no, it wasn't. If they say, what was wrong with my question, you say, the light was yellow when I went through it. But be sure to, if you're correcting an inaccuracy, be sure that you do so calmly and clearly. Now, another trap are assumptive questions. And this is a question that builds an assumption that's false and expects you to be able to answer yes or no. And if so, then challenge the assumption before answering. Now, a lot of times attorneys will deliberately try to see if they can get your ire up. They're designed to provoke you to get mad, because what they're hoping to see is whether or not at trial they can figure out which buttons to push to make you appear to be angry, to make you appear less credible. So be sure to do your best to stay neutral. Don't get upset. Just answer the question. Don't go for yiping and snipping at the attorney. It will not come over well. Now, if you answer a question, everyone will assume that you understood the question. So if an attorney, and attorneys do it all the time, we use legalese. We will use often fancy words when a much more simple word could be used. If you don't understand or know what a word means, this is the time to say, I don't know what that word means. Or can you explain what that word means? Because if you answer, everyone will assume that you knew it. For instance, if you're not sure what the term perimeter means, if the attorney says to you, were you standing at the perimeter of the yard? If you don't know what they mean and you say yes or no, everyone will assume that you understood, and now you've placed yourself either near the fence or away from the fence. So if you're not sure what perimeter means, just say so. The attorney can say, what I mean by that is the fence line or the property divide, but ask for clarifications. If you didn't hear the whole question, or you're not sure if you heard the whole question, just ask if the question can be repeated. Many times the attorney will ask the court reporter to read back the question so you can hear it exactly. During the process, you need to know that you have rights. You can request a break, which means you can go to the bathroom, you can talk to your attorney, you can ask for clarifications of questions. If you find that you've made a mistake and you're testifying through and you said that you graduated in 1975, and you sit and you think about it a little bit more as you're going on and you go, oh no, I didn't graduate in 75. I graduated in 79 from that school. You can say to the person, I need to correct some testimony. And a correction can be made right there at that time. If you are represented by counsel, on a break, tell your counsel that you made a mistake or misstated something and it can be fixed. When we talked earlier about a question being answered and you taking a pause and thinking about your response, that pause allows your attorney to object to any inappropriate questions. And that preserves the record to see whether or not that question and answer set can be used in court. Now, as a hint, I'll tell you, if an attorney objects that a question is vague and ambiguous, unless you've got some expertise in the matter that the attorney doesn't, and I mean, if perhaps they were using, if you're an expert in an area and they used a term of art in your area, then maybe you understand the question and the attorney doesn't. But generally speaking, if an attorney says a question is vague and ambiguous, the best thing to say at that point is, I don't understand the question. Can you restate it? And that way you can hear what the question is. Now, your attorney will object when needed. They're going to be there to protect your rights. We'll make sure that we stop inappropriate questions, and we'll advise you during the breaks. We can't answer the questions for you, but I'm there at depositions to make sure that my client's rights are protected, and I'm there to support you. Now, after deposition, what comes afterwards? Well, once your deposition ends, roughly 2, maybe 3 weeks later, a written transcript is prepared. That transcript will be sent to your attorney or to you, and you will have, unless it's changed, unless the attorneys agree to something different at the deposition, you will have 30 days to review that for accuracy. And that means you read through every single one of your answers to see whether or not you misstated something. And it might be your mistake, or it might be a mistake that the court reporter did. For instance, we talked about you graduating in 1975, but if you had said 1979 and they wrote 1975, we need to go through and change that answer. So you would put in and tell everybody that that answer should be 1979. And at the end, after you've reviewed it and you've made any corrections that you need to make, you will sign that deposition under oath, saying that it's all true and correct. If you don't correct anything, or you don't sign saying that's all correct, the court deems after 30 days that your testimony is then set in stone. Now, I'm going to caution you that if you go to a deposition and you give testimony, and then when you look at the testimony, you start writing and making a lot of changes, the attorney who took the deposition or any other attorney that's opposed to you in the matter may comment very strongly at court about the fact that you've changed so many answers, and that can really affect your credibility. But again, you want the deposition transcript to be correct. So the time to prepare to make sure that you can give the best answer is to prepare before the deposition. Now, your testimony, as far as the deposition concerns, has a big impact on settlement. if you've got strong, consistent testimony and you appear to be a very credible witness, a sympathetic witness, that really makes a difference in your position as to how you go into a settlement. It clarifies and strengthens the strategy that an attorney can use on settlement. Now, impact on trial. Now, testimony can be used to refresh your memory. So if you are deposed 6 months after the accident occurred and trial isn't taking place for 4 years, and if you said at trial, I don't remember what I was wearing on that day, then somebody could say, well, if I show you your testimony from your deposition, would that refresh your memory? And you can then review the testimony that you gave at deposition, and you can tell them whether or not it refreshes your memory. If it refreshes your memory, you can then testify as to what you were wearing. Now, it can also be used for what we call impeachment purposes. And this is where you give testimony at trial and you say the light was red when I went through it. But if maybe I should say, you would say the other thing. You would say that the light was green when I went through it. But if at your deposition you had said the light was yellow, the opposing counsel may well pull up that deposition and read to the jury or the judge the testimony where you said the light was yellow. So it may, if they're using it to impeach, where you're saying one thing at trial and saying a different thing in deposition, it may reflect very negatively on your credibility. So again, it's one of those things you want to prepare before your deposition, just as if you would be preparing to testify in trial. So, and it's sort of obvious that clear, truthful statements support your credibility. After reviewing your transcript, your attorney will reassess the overall case strategy, will often determine the strongest next steps, and communicate timeliness and expectations to you. Takeaways from today's webinar. Depositions are very, very manageable with preparation, but I stress you should prepare yourself, and that means you should review all the documents that are pertinent. Sit and think about the timeline, think about what happened. And remember, you have rights and you have support there. So your attorney will be there, and you have the right to make sure you have a break. You have a right to make sure that the questions are clear and concise. Make sure your answers are calm, clear, and truthful. And always remember that your attorney is there as your advocate throughout the deposition. Now, I don't want you to be worried that somehow if you forget a little part of the matter, that's going to be critical. The issue is you should remember the main events. You should remember the general timeline. And if you prepare yourself for that, you should be just fine. Nobody can give the same exact answer each and every time. So to the extent that there's small deviations, will not be a problem. Conclusion. How can we help? Well, we can help you decide on how to approach the deposition. We can prepare you for that deposition. We can make sure that we have gone over with you all the relevant documents. We can go through with you as to what your legal responsibilities were at the time that the incident that's being litigated was concerned. For instance, if you're a trustee, we would go through with you and explain to you and make sure you understand all the duties that a trustee has. And we would go through with you the fact pattern to make sure that you know that you can answer each question. Were you loyal to the beneficiaries? Did you keep the beneficiaries informed? All those things we can help you with. We're there at your deposition to support you and to protect you. Pergolo. Well, we've been open since 1979, and as you can see here, we have says 10 full-time attorneys, but we have 12, and we've got one counsel. We have probably now over 400 years of combined attorney experience. Many of our attorneys have advanced tax degrees. We have certified specialists in probate, estate planning, and trust law. We've got over 45 very highly qualified support staff. Our staff is diverse and it has a tremendous amount of skills. As I said earlier, we have 8 offices, plus we have virtual platforms such as Zoom and Microsoft Teams that we can meet and help you with. We're here to help. You can call us. You can visit our website. You can email us. At the end of this, you're going to be asked to complete this digital evaluation. So I'll ask you to do that. Now I'm going to check to see whether or not we have any questions. I do not see that anybody has posted any questions. I'm checking hosts now. I see that there aren't any questions. So at this time, I'm going to sign off, but I ask you to please fill out the digital evaluation. And should you be facing a deposition, please feel free to call our office. We'll be more than happy to help you. We represent plaintiffs, defendants, and I have represented many people who are just third-party witnesses who are concerned when they've been subpoenaed that perhaps someone is trying to make them a party to the litigation, depending on how they testify. So again, we are here to help you if needed.